Welcome, everybody. This is the Gerling Law Introduction module to bankruptcy. If you're watching this video, then you are probably being groomed to be either a bankruptcy paralegal or you perhaps are in a sales role with the organization. Depending on what your role is, you're probably going to have a series of different modules here over the next couple of days or so. But let's go ahead and jump right on into this module. So this is obviously this module is obviously intended to just give you the basics on bankruptcy. So what exactly is bankruptcy? Well, pretty simple stuff here, right? It's a legal process where the debtor is declared insolvent, and the courts are going to do something about providing relief to the debtor for one, and in some instances distributing the debtor's assets out to creditors. Now, the bankruptcy process, once a debtor files bankruptcy, creates a series of protections, and the most important protection that a debtor gets is something called the automatic stay. And it's automatic because there's no need for a court order. All that has to happen is the debtor files their bankruptcy petition, and there isn't a lot to these bankruptcy petitions. They have a very there's a very low threshold of information that has to be provided. As soon as that file stamp hits the document, that stay is in effect. And if a debtor, or if a creditor has any knowledge of the bankruptcy filing, that bankruptcy stay applies to them. If they violate that bankruptcy stay, then there can be some very severe punishments for creditors. Last several years where creditors have gotten burned on that sort of thing, they've been popped with sanctions, dollar penalty or monetary penalties in the neighborhood of $50,000, and that's both big lenders and individual creditors who just decided who unwisely decided to ignore that automatic stay. And it doesn't matter. There's no formalized. They don't have to be served the process server. All the debtor needs to do is hand them a copy of their bankruptcy filing. Even telling the creditor that a bankruptcy is in place is enough to have the stay apply to the creditor. Now, there are different outcomes in the bankruptcy process for debtors. In some instances, the bankruptcy process will reorganize the debtor's debts. And what I mean by that is the bankruptcy court might adjust the interest rates on the debtor's loans. Some of the debts might be forgiven. Portions of the arrearages, the unpaid portions of the loan might be forgiven, and the debtor is allowed to make ongoing remaining payments. There are a lot of different types of outcomes that debtors can enjoy depending on the type of bankruptcy they're filing in many cases. So there are some limitations for debtors. A debtor can't, knowing that they're about to file bankruptcy, go to a buddy of theirs who, for example, whom they owe, let's say $10,000, and pay that guy, $8,000 because they happen to have that amount of cash, and then file bankruptcy and then screw over the other creditors. Well, the problem with doing that sort of thing is that $8,000, the bankruptcy code would probably have that $8,000 distributed differently to the other creditors. Some creditors get higher priority over others. We're going to talk about that in another module. But this preferential transfers concept prevents debtors from essentially making decisions about how their own assets are going to be filed. The preferential transfers can be reversed. Essentially, the creditor receiving the money can be forced to return that money to the bankruptcy trustee. We'll talk about who that is shortly. But they can be preferential transfers can be reversed up to 6 months prior to the bankruptcy process. So that's something that debtors have to be careful for. So real briefly, how did we get to a point to where we have this current system of bankruptcy? Well, ancient Greece addressed these issues of insolvency by forcing the Greek citizen into what was called debt slavery. So that meant that the debtor himself, usually it was he and his family members, children even, would be cast into slavery until such time that they paid off their debts. So would their slaves if they owned any. It was a lighter version of slavery as compared to what slaves from foreign countries, which were subjected to in ancient Greece, but it was slavery nonetheless. Genghis Khan would, after your third declaration of insolvency, would execute you. So that's pretty no surprise there with Genghis Khan. In the Old Testament, there was a concept of jubilee. I want to say that happens every 7 years. That happened every 7 years. In other words, all of the debts would be forgiven. I could be wrong with that timeline. So in other words, if there was any outstanding debt, it was just wiped out on an automatic basis. And you know, that kind of, in a way, we kind of inherit that concept kind of applies to modern bankruptcy. I think you'll see what I mean here later. In medieval Europe, you had king's courts and you had ecclesiastical courts. And ecclesiastical courts were the church courts. Those were the courts of mercy. And that's really, in our modern system, we're still split out between criminal courts and civil courts. And so the king's courts in medieval England, for example, really transitioned into what we have in the U.S. right now as criminal courts. These church courts, these ecclesiastical courts, morphed into our civil court system in the U.S., and bankruptcy falls under this ecclesiastical system. Despite having those two systems, not everybody in Western Europe, and including England, enjoyed access to those ecclesiastical courts. In England in particular, they got into using debtors' prisons, which over time they started realizing was neither good for the debtor nor the creditor. So the English courts ended up developing the early stages of what we now know as bankruptcy, which, as I mentioned earlier, is part of that civil court system that has arisen from the ecclesiastical courts. So what is the purpose of bankruptcy? Mercy. Remember, the concept of bankruptcy comes from these ecclesiastical courts. But the primary purpose is providing some type of financial relief to the debtor when they've just dug themselves in too deep. This is not necessarily relief for the creditor. In fact, it almost never is. The Supreme Court has even gone as far as saying the principal purpose of the bankruptcy code is to grant a fresh start to the honest but unfortunate debtor. Well, I think you're probably going to see as you start getting into these cases, especially for you paralegals, there are very few debtors who are ever deemed dishonest despite filing. You might have a debtor who files bankruptcy over and over and over. It's hard for these courts to reach this designation of dishonest. Not saying it never happens, but it's just kind of unusual. So one thing that's kind of unique about the United States is our bankruptcies are handled strictly by the federal courts, and that's a function of the U.S. Constitution. One of the articles in the U.S. Constitution establishes that bankruptcy will be managed by our federal court system, and specifically not our state court system. So all bankruptcy courts are federal courts. You can think of them as being one step below a U.S. district court. So if you've done some training so far on federalism, and you've learned about the different court structures in Texas, you're familiar with probably how justice of the peace courts in particular are kind of one notch below a trial court known as a county court at law. The federal courts use a very similar system. In a way, a bankruptcy court feeds into a U.S. district court, which is a trial court. And if you see my diagram under this picture, that kind of helps you understand it. In the U.S., we have 94 trial courts, and all of those feed into the U.S. Court of Appeals, and then, of course, those 11 courts of appeals feed into the U.S. Supreme Court. and you're probably familiar. I imagine you're familiar with the U.S. Supreme Court by now. So let's talk about the different types of bankruptcy. There are several types of bankruptcies out there. One is Chapter 7, and that's where your unsecured debts are probably going to be liquidated. Chapter 9 bankruptcy is a specific area of the bankruptcy code for municipalities, and it happens from time to time where a city will go bankrupt. They can no longer meet the debts that they incurred by floating bonds. A recent example, I'm filming this in 2018. A fairly recent example was the city of Detroit filing bankruptcy. Chapter 11 is a reorganization typically for businesses. However, high asset individuals can also use Chapter 11s, but per individuals doing Chapter 11s is kind of rare. Chapter 12 is a process for really reorganizing family farms, and that's nothing we'll really deal with. And then Chapter 13 is one we arguably deal with the most. That's a personal bankruptcy, just like Chapter 7 typically is. And businesses can file Chapter 7 as well. But we mainly are going to be dealing with Chapter 13s, which are primarily individuals seeking reorganizations. It's kind of like they get on payment plans, if you will. I mentioned that earlier with the reorganization of debt. We're looking at modifying interest rates, that sort of thing. And typically under a Chapter 13 plan, the debtor starts making one payment. A payment will come often automatically out of their paycheck and go directly to a trustee, and the bankruptcy trustee will distribute the funds to the portions of that withdrawal to the various creditors. Oh, and there's Chapter 15, which is kind of a new one. That's a cross-border reorganization, cross-border bankruptcy, and cross-border. We mean international borders. So that's really nothing that we're going to get into. That typically is going to have. I think that's going to have more to do with business-related bankruptcies that international businesses doing business here in the U.S. So typically, most of the time, probably 99.9% of the time, a bankruptcy is voluntary. In other words, that means it's the debtor who's filing the bankruptcy. The debtor is going to the bankruptcy court and seeking relief. But there is a possibility to do an involuntary bankruptcy. And for those of you on the sales side, or if you're involved in any collections activities with the business, that's something that you might be talking to some of our tenants about, is the possibility of us doing filing an involuntary bankruptcy on the debtor, and that's where one of the creditors files bankruptcy on behalf of the debtor, seeking the bankruptcy court's approval and involvement in distributing the debtor's assets to various creditors. There's standards for that, and we'll talk about if you're involved in that sort of thing. We'll talk about that in more detail. So that's it for now. That's all we have left on your introduction. That's pretty much the basics for bankruptcy. We're going to go into we're going to dig a little bit deeper into the bankruptcy process here in a minute. The next module is going to cover things like the bankruptcy process on a high level and things like trustees, that sort of thing.